Welcome to this episode of The Diary of a Lawyer, and welcome to a brand new explainer. Today, we're diving deep into the high-stakes, honestly pretty dramatic world of maritime insurance claims. We're going to pull back the curtain on our source material to explore what really happens when a massive cargo ship is in distress or a multi-million-dollar hull gets battered by a brutal storm out on the open ocean. Now, I know insurance might sound a bit dry at first glance, but trust me, in this world, situations get very interesting and very legal very quickly.
Here's what we're covering today: lodgment and legal duties, investigating the claim, legal review and subrogation, settlement and arbitration, and finally, key takeaways for claims. To make this really tangible for us, we're actually going to treat the claim file as a literal diary. We'll track one single claim from the inciting disaster, flipping through the pages of this diary all the way to its final legal resolution.
Okay, let's dive into this. Our journey takes us through 4 key steps: lodgment, investigation, legal review, and resolution. Basically, this is the complete life cycle of our diary, from that crazy inciting incident all the way to the final handshake or court verdict. Section 1. Lodgment and legal duties. So, open the first page of our diary. Imagine the scene. It's a frantic first phone call from a shipping company in distress. We've got a breach in the hull, or our cargo is compromised. Well, that initial call to the insurer is absolutely critical because it legally triggers the entire claims process. And immediately, the duty of disclosure is activated. What does that mean? It's the legal obligation of the insured to provide all relevant facts, even the ones that might actually hurt their claim. Honesty is legally paramount from day one. Seriously, if a shipping company tries to hide something or just fails to disclose a material fact, the insurer has the right to deny the claim completely. The entire foundation of the claim rests on total transparency. Now, the second vital duty is the mitigation of loss. This is the legal requirement to take reasonable steps to reduce the overall damage, because action is just as important as honesty here. If a ship's hull is breached and valuable cargo is taking on water, the company can't just abandon the goods, throw their hands up in the air, and wait for a big insurance check. No way. They must actively try to save whatever they can to minimize the financial bleeding. Section 2. Investigating the claim. Turn the page and we enter the detective phase of our diary. This is where claims adjusters step onto the scene to verify the facts. Sometimes this is an internal team, and sometimes it's a squad of third-party maritime experts. But the core mystery they have to solve is simple. Does this incident actually fall under the policy? They're checking for causation. Was the damage caused by a covered peril, like a sudden violent storm, a collision at sea, or maybe an act of piracy? And if it was, what exactly is the extent of the recoverable loss? They literally have to separate every single dollar of damage into what's covered and what isn't. Which brings us to the inevitable gray areas. Consider the difference between a covered peril, like sudden storm damage, versus poor maintenance, like overdue safety inspections. Adjusters constantly find situations where these two concepts just blur together. A ship gets damaged in the storm, right? But maybe the hull seals were old and totally neglected. This blur is exactly where maritime lawyers have to step in. It takes real legal expertise to interpret the specific terms of the policy and figure out where the legal line is drawn between a true accident and simple negligence. Section 3. Legal review and subrogation. Now we are squarely in the legal strategy phase of our diary. The physical investigation is done, the photos are taken, and the lawyers take over, scrutinizing every single report, invoice, and email, looking for coverage defenses. And this brilliantly illustrates how abstract legal concepts come to life. Look at this real-world scenario. A ship's engine fails during a severe storm, but the maintenance records show the engine was actually way overdue for an inspection. In a case like this, an insurer might use that exact evidence to argue for a partial denial of the claim, basically saying, hey, the failure wasn't just the storm, it was your lack of maintenance. The legal strategy here directly dictates the financial outcomes.
Now, what's really interesting about this slide is this additional layer of legal complexity called subrogation. Subrogation is the process where an insurer pursues a third party who actually caused the loss in order to recover their payout. So think of it like this. If your ship is hit by another negligent vessel, your insurer pays you to fix your ship. But then they use subrogation to legally go after the negligent vessel's owners to get their money back. It's a fascinating strategic maneuver that happens entirely behind the scenes.
Section 4, Settlement and Arbitration. We're now entering the final stages of the diary. The detective work is complete, the legal reviews have established the boundaries of the coverage, and payouts are calculated based on those verified losses. But what happens when the parties just cannot agree on a final settlement number? Well, they turn to formal resolution paths. That means mediation, arbitration, which our source notes is actually incredibly common under London maritime law conventions, or formal court proceedings. In these super high-stakes settings, that meticulously documented claim file, our literal diary of the event, becomes the absolute decisive piece of evidence.
Section 5. Key takeaways for claims.
As we get ready to close the diary on this topic, let's distill the most critical lessons from our source material into 3 main pillars. Number 1, timeliness. You must report losses promptly. Late notice can be absolutely fatal to a claim. Number 2, transparency. Disclose all material facts honestly, right from that very first phone call. And number 3, documentation. Keep absolutely all records of communications, repairs, and inspections. So the crucial point is, despite the massive complexities of maritime law, success really comes down to trust, following proper process, and just being highly organized. I want to share this incredible quote from the seasoned maritime lawyer from our source text. He says, "Every claim tells a story, and behind every number is a human or a ship waiting for justice." I absolutely love that perspective. It perfectly emphasizes the real-world human stakes that exist right behind all this seemingly dry legal paperwork and policy jargon. Which brings me to a final question for you to ponder. If a storm hit your operations today, is your documentation actually prepared to tell the true story of the crisis? It's a provocative thought, right? Whether you're navigating international shipping lanes or just managing risks in your own daily operations, your preparedness in the face of unpredictable disasters is entirely up to you, and how well you keep your own diary. The Diary of a Lawyer and all its content published is strictly for educational and informational purposes only. Nothing presented here constitutes legal, medical, or mental health advice, nor does it create an attorney-client relationship, and does not constitute professional advice. Please be sure to consult with a qualified professional in your jurisdiction regarding your personal situation for advice that is tailored to your specific situation.